So good morning again, officially. I am Liz Isaacs, and I'm here with my colleague, Lauren Peretti. We are from Housing Innovations, and we are doing training on VAWA requirements for CoC projects. I'm sorry, I'm having screens pull up here. So I'm hoping that's why you're all here, just making sure we're all in the right place. To just let you know, we really want this to be as helpful as possible for you. We are still learning because HUD is providing information to us slowly. We just have some new information. We have kind of limited information. So we are going to do the best job here. If you have questions, we'll answer them to the best of our ability, given what HUD's provided. We're happy to do research on anything we don't know about. And some things may be a little bit, stay tuned on when HUD provides some more information. Please ask questions. Well, it's not all about fun, but it's more fun if you ask questions, more interesting for everyone to not just hear our voices. But again, this is for you guys. Nothing here is obvious. Nothing is intuitive, and we all have to learn it. So slow us down, ask questions, ask us to back up. We are thrilled to have this be interactive. So please, do that. Again, we want this to be useful to you. And after we do today, we will post the recording. We already have the slides posted. We may go through, if we ever have any changes, we'll update the slides as needed. And then we'll email those out as well. So if you want to hear this again, or you want to post, you want to have a colleague take a listen or look, you have the ability to do that. All right, so what are we going to do today? Here's our agenda. We're going to give you a basic overview. We're going to look at who's eligible, what your responsibilities are as CoC providers, what your documentation requirements are. We're going to talk about prohibition on retaliation, the folks' right to report, and VAWA eligible activities. You're going to hear us, some people use the word survivor, some people use the word victim. And our suggestion is that the folks that you're working with, the applicants or the tenants or the clients, you ask those folks that you're serving what word they prefer to use, whether it's survivor or victim. Okay. Next slide. So we want to know who's with us today, just so we get a sense of who's in the room. So I am going to launch this, and if folks could answer and let us know what CoC projects you work in and how familiar you are with VAWA requirements and protections. And there are no extra points for knowing everything or knowing nothing. We're just really interested in what people do or don't know. So you have questions 1 and 2 to answer. We'll give everybody a minute to do that so we know who's in the room and where people kind of fall in their knowledge base. Everybody's chugging along. We'll give you 20 more seconds. All right, last countdown. We have most of you answering. And do a 3, 2, 1 if you haven't answered. Okay. All right, so we're going to share the results. So we've got, everyone can take a look. We've got lots of permanent housing in the room. So we've got PSH and rapid rehousing primarily, and you guys may work in more than one program here. We've got a little bit of transitional housing, our friends at Joint TH Rapid Rehousing, some Youth Navigator and other. Not sure, that's fine too. The others, you're welcome to throw what you're doing in the chat if you want to share that with us. And it seems like the vast majority of folks are a little familiar with VAWA. A few people are falling into that VAWA, which is totally fine. And then some people maybe have more familiarity with what's happening. Also, if you have any particular questions that you want to get answered today, so maybe we are going to cover it, maybe we aren't, depending on when you looked at that agenda, please feel free to throw it in the chat. If it's related to VAWA and what we're doing here, we'll certainly answer it. If it's a little bit off topic, we'll still try to answer, or we might get back to you. But please, this is your opportunity. If there's something you really want to ask us, please throw it into chat, and I see that we have victims of case manager. Oh, great. We have 211 in the room. Awesome. This is great. We've got community health workers. Fantastic. Oh, welcome. And we'd love to have all different folks learning about VAWA in the room. So thanks for joining us.
So I do just want to say that our content is very specific to the VAWA requirements as they relate to continuum of care programs. So we are super stoked to have other partners in the room, but know that what we're going to cover about VAWA is not going to be comprehensive for what you may need to know about VAWA based upon however you're funded. It really is specific to the CoC program.
Yep. Thank you, Lauren. That's helpful to know. All right, I think we're gonna move on.
And that, Liz, you may have said this. Sorry, I was distracted looking at the
Okay.
chat. But if anybody has any particular questions that you want to make sure we, you said that already?
That's okay. You can't say it enough, as you know. We can't say it enough because we want your questions. So I like it. It's all good. Yeah.
Throw them in chat, and we'll answer as many of them as we can.
Great. Next slide. So what is VAWA? So VAWA is a federal law. It gives protections, specifically housing protections, to people living in housing units that are subsidized by the federal government who have experienced domestic violence, dating violence, sexual assault, or stalking. And the idea is to keep people safe and to try to eliminate, or at a minimum reduce, people's chances of becoming becoming homeless. And then the protections apply regardless. It does not matter sex, sexual orientation, gender identity, or gender expression. And we know that in general, women overwhelmingly are the survivors or victims from domestic violence, but it's important that folks really understand and see this definition and understand this definition. Okay. So before we get started on all of this, we wanted to say why this matters. Why are we talking about this? And we know that DV can be a common cause of homelessness, and that it's really important to keep people safe in their homes to try, like I just said, to reduce homelessness. So we know that people have really serious safety needs, and that it's really important that there are housing protections in place to keep folks as safe as they can be. As I said, the goal here is to have safe housing, or one of the many goals, but an important goal is to reduce the risk of homelessness. We also want to make sure that we're decreasing evictions happening. We don't want people to be denied housing assistance, and we don't want survivors to experience violence in their homes. And we know that keeping people feeling safe in their home also builds trust with staff people and the folks that are trying to really work on housing stability and provide those services to folks. So for all those reasons and others, this is really, really important, and that's why we're talking about it today. So what's covered? What are we talking about today? So these are the HUD programs that are covered. So, and folks may know some of these, may be very familiar, less familiar, but it's Section 202 and 811, HOPWA programs, CoC and Emergency Solutions Grant, which we're going to talk about in a second, home projects, Housing Trust Fund, Housing Choice Vouchers, all public housing, and multifamily rental housing. Next slide. And then specifically, as we're talking about HUD housing programs, in the CoC, we're talking about rapid rehousing, transitional housing, and permanent supportive housing. And for emergency solution grant, we're talking homeless prevention and rapid rehousing. I'm going to stop for one moment. I'm talking fast. Does anyone have questions, comments, concerns? Okay, keep going. So what are the VAWA housing protections? So VAWA protects folks, so there's no discrimination allowed based on someone's status as a victim or survivor of domestic violence, or on adverse factors. So an adverse factor is any factor that can be used as a basis for denying admission or terminating assistance in a program or evicting a tenant. And a survivor cannot be denied or terminated based on adverse factors if it's determined that it's a direct result of the status of a survivor or of domestic violence. VAWA also protects by providing folks the ability to do an emergency transfer. We're going to talk later in detail about that. Also for lease bifurcation. So lease bifurcation is when someone is removed from a unit when there has been violence in the household. Also, there's a prohibition on retaliation. So there's no ability to discriminate against a DV survivor because of what has happened. And then folks also have the right to report crimes and emergencies. And we're actually going to talk about all of these in detail as we move ahead. So who's eligible for VAWA? So we know that applicants for and participates in HUD housing programs who are victims of domestic violence. We've talked about this: domestic violence, dating violence, sexual assault, or stalking. Okay. And who else is eligible? So other folks that are eligible under VAWA do include guests or household members. Live-in aides are eligible. Guests are able and protected by the right to report. A tenant can seek protection for a live-in aid, including an emergency transfer. And then people who are affiliated with a tenant facing adverse housing decisions as a result of VAWA may also be protected. And an affiliated individual is someone who is a spouse, a parent, a sibling, a child, or an individual that is living in the household or a lawful occupant in the household. So I'm reading my notes on that one. Questions, comments? I see stuff going on in chat. I don't know if those are questions or anything we need to provide clarification on.
Sorry, hang on, I'll look. I think we have, what about those who are not in any type of HUD housing? Are they protected by VAWA? So that's like in an area. So our focus for today is going to be on the CoC program, which is the information that we've gotten about this by HUD. So we are not going to be getting into today other types other than the covered housing programs that Liz went over. Those are definitely covered housing programs. So it's not just the CoC program that's covered, but I don't know what else, what other. VAWA is an enormous piece of legislation, and it's got a lot of stuff in there that we are not gonna cover today. So I'm sorry, but I don't know the answer to that question.
See that Deanna has her hand. Deanna, do you want to ask something?
Yeah, I was just wondering on the last one, people who are affiliated with a tenant facing adverse housing decisions, are we going to expand on that more? I'm not really sure what that means.
Sure. So do you want, and I ran through it quickly, do you want me to do the definition of affiliated again, or is your question more sort of procedurally how that happens?
Maybe a little of both. Are you going to cover it later on, or is this it? I think a little.
I don't think we cover later on the definition of someone who's affiliated.
Yeah, so let me do that definition and see if that's helpful. So we're talking about a spouse, a parent, sibling, or child of an individual, or an individual an individual to whom that individual stands in loco parentis, or any individual, tenant, or lawful occupant living in the household of that individual.
Okay, that's what when it said affiliated, I was like thinking, well, a friend or something. So a household member that is in the household.
Yeah, yes. and an example might be, Deanna, right? Like that you've got somebody that is, living in the household, right? That is not the qualified participant, but is subject to a domestic violence situation. that person is also going to have, be entitled to VAWA protections. Or as Liz said, there's a live-in aid, right? So somebody needs a live-in aid, and the live-in aid, right, is subject to, as a survivor and experiencing some sort of safety threat. The VAWA protections are going to extend in those cases. And in loco parentis just means somebody that is standing like as if they were a parent, right? They've got, parental responsibilities for a child, even though they are not the actual child of the parent, the actual parent of the child.
Yes.
Okay.
And
All
I
right,
think, Adrian, I'm sorry. Did you have something else, Dan? I'm sorry, I didn't mean to cut you off.
No, that's okay. Yes, it did. Thank you.
Good morning. Yes, I hope everyone's doing well. I just had a question about, I guess, hypotheticals of how this might actually be applied to guests and these other participants who are eligible. Like, how would a live-in aid benefit from these protections? How might they be used?
Oh, Lauren, you're muted. Oh, all good.
We're going to go into a lot more detail later about specific examples of the protection. So just really quickly now, I'll give one quick example for a live-in aid, right? Like, so a live-in aid is the victim of domestic violence, and in order for, the person to remain safe, they need an emergency transfer to a different unit. So even though it's not the qualified CoC participant who is the victim, that household, including the live-in aid and the person whom they're assisting, are going to be eligible for an emergency transfer. That's an example. And we'll talk more later about what an emergency transfer means. So I think some of this will become clearer as we go through the presentation and show you guys some examples of how this works in practice.
Great, thanks, Lauren. Anything else? Really good questions. Thank you so much. And we hear you're listening. That's so exciting. No one's multitasking. Some people might be multitasking, but we love people asking questions and really being on task here, and really good questions too. So when we talk about domestic violence, what's the definition? What are we talking about? So it does include misdemeanors and felonies by a current or former spouse or intimate partner of the victim. But it's also really important that it is not just about abuse that constitutes a crime. So the criminal stuff might be easier to point to, but it's important to remember that there's also verbal abuse, psychological. There may be economic abuse. So for example, someone might be not allowing the victim to access money or credit. They may be unfairly using resources in the house. They may have a lot of abuse and be exerting influence over financial decisions. So a lot can be happening. Again, I think what's important out of this is to remember not just a crime, and to really broaden in your mind. I know as I'm learning this, it's been broadening in the definition in my mind. What is abuse? And it also can be technological. So any kind of technology used to harass, control, threaten, exploit, monitor someone. So there's a wide variety, and we'll talk about this in a minute, but I found it helpful to go to the, is it the CT Connect website, and they have a whole page on what is abuse. So if you're not sure, we'll talk about this later, but if you're not sure, there are resources out there to help us all better understand what the definition of domestic violence is. Okay. And so DV may be committed by someone who is in the apartment, so they're cohabitating or has cohabitated with them as a spouse or as an intimate partner. Maybe they share a child with the victim, or they commit an act against the youth or an adult victim who's protected from the acts under Connecticut's family or domestic violence laws. I'll pause there for a second. Okay, all right. We are going to do another poll. And we would like to know some true false questions, some other questions for you to answer, and another true false. So if you can take a moment, We've launched the poll. We'll give everybody a minute or two. There's no grades. There are no grades here. We just want to see how everybody's doing. I'll give everybody about 30 seconds. All right, I'm going to end the poll. I'm going to share the results with everyone. So great. Folks know that while women are overwhelmingly the folks who are victims of domestic violence, VAWA protects everyone regardless of gender. And then what types of projects of the CoC are covered under VAWA? So all of them are covered except street outreach. We talked about rapid rehousing, transitional housing, and permanent supportive housing. And to be eligible for protections under VAWA, a CoC tenant must have been the victim of a crime. And so that is not true. So they may have been a victim of a misdemeanor or a felony, but you may recall a couple slides ago, we talked about how the definition of domestic violence is much broader than a crime, that there are many different ways that DV can manifest itself. So make sure, and we'll talk about it in another slide or two, that you really are familiar. Again, it was really helpful for me to go to the website and look at the broad definition of domestic violence and the many different ways that it can manifest, not just through a crime. I'm going to stop sharing. Any questions? Questions, comments, concerns? All right. We will keep going. Sorry, I need to get where I lost my way. So what is a housing provider responsible for? So you provide housing. These are really important things for you to know, and you really want to be knowledgeable about VAWA housing protections. And I know I say this a lot as it relates to HUD. It's not all intuitive by any means. So it really is incumbent upon the housing provider to learn this stuff. And by learning it is to come to trainings like you're here today, but also to be willing to read the resources, see what you need to do, and really be mindful as you're bringing folks into your program of what you need to be sharing with them about VAWA, because there are requirements. We're going to keep talking about that. So you want to, and when we say proactively, like you're here today, you're proactively learning about VAWA. So you want to make sure that you continue to be proactive and learn about all the different housing protections that are available to folks. You want to make sure that you're sharing with all of your applicants, all of your tenants about VAWA. And you're going to have notifications Lauren's going to talk about that are required. But it's really important that you're sharing this with everyone. You're not thinking about, oh, maybe this person needs it. Maybe this person's a survivor. This information is for everyone you're providing services to, which is why we're really happy to have a wide variety of CoC folks, because it really impacts all of the CoC folks. You want to always make sure that you're helping folks with emergency transfers, and we're going to talk about that in a little bit, because that's critical that that's being done, and that that's being done the right way and following the rules that are in place to keep the survivor as safe as possible. And then, as always, as providers, and you guys are good at this and know how to do this, but you want to make sure you're doing it for your for all survivors as well, which is making sure that they are getting the proper supportive and legal services. And again, you provide that to everyone, but it's really important to know what's out there for survivors as well.
Two things I just wanted to underscore really quickly here. So you are responsible, as a CoC provider for being proactive in helping to identify where people may have VAWA rights and helping them to exercise those rights, right? So you don't want to wait for somebody to say, hey, I have a VAWA right to an emergency transfer. I need an emergency transfer, right? If you see someone in your program that needs an emergency transfer, even though they may not know that they have the right or understand it or seek it, right? It's really up to you to proactively help them to understand that they have that right and to exercise that right. And then the other thing I wanted to say here is that this stuff can be very, very legally complicated. And so connecting people with an attorney that can help them to understand the complexity of their individual situation, and how all of the laws, that govern tenant landlord interactions in the state of Connecticut apply in their particular circumstance, right? Oftentimes, you really need an attorney to give really good legal advice. So please, if you're struggling with things, we've got great legal services providers in Connecticut. Don't hesitate to try to get people connected to those legal services.
Oh, that's great, Lauren. That's really helpful.
Did I skip one? I did.
It's okay. So I was just talking a little bit about this, and Lauren just gave some really great examples about what it means to be proactive, right? So if you're seeing something, please say something, but in being proactive, making sure that folks know. So again, as soon as they're applying, they're coming into your program, and again, we'll provide more detail on this as we go on, but that folks know about about their rights, and then about the resources. And I talked a little bit about this. I thought this was helpful to take a look at CT Safe Connect. They have a great website. Is it abuse? So just like we were talking about, again, it's not just a crime. It's not just a crime that may be a misdemeanor or a felony, but the definition has lots of different elements that it could be. So please take a look at this. I think it's really helpful. And important that people really have a sense of what domestic violence is about as we're trying to make sure people stay safe and to follow rules. Does anybody have a question? I thought I heard someone. Nope. Okay.
Hi, I have a quick question. Kristen Green, I'm having technical difficulties today, so I'm sitting with Stacy. My question, psychological, emotional, verbal abuse is so hard to prove legally. Do you have any suggestions on documentation or anything? It's just so gray.
So we're going to talk about documentation requirements later,
Okay.
in terms of documentation requirements that you need in order to, or can ask for, I shouldn't say you need, can ask for when someone is seeking to exercise their VAWA rights. So maybe we'll put a pin in that for a minute because we'll get to it later. Is that?
Okay, thank you.
That's great. Thank you. Okay. So Lauren just talked about this. I talked a little bit about it. We want to make sure that folks are getting referrals for any kind of services they need for legal assistance, both of them really critical in domestic violence situations. CT Safe Connect has a fantastic website. We've got the link there. We've got information on phone and email, and we really, again, just if you can, hop on the website. And like Lauren said, being proactive, knowing what's out there, I think is really helpful so that when a situation comes up that you see, you have a sense on how to handle it and you're not scrambling. So again, we're so lucky in Connecticut to have such amazing services out there for folks. So please use them. And then Safe Connect also can connect you to other services as needed. Okay. So we talked a little bit about this, where you're going to educate folks on VAWA protections. There are some requirements for notices that need to happen. Folks can't exercise rights unless they know what they are. So you want to make sure that at each of these times, people are given the information needed. So when admitted to CoC housing, or they begin getting assistance, when denied CoC housing or assistance, when a participant receives notice of eviction or when a participant is notified of termination of assistance. So you want to make sure that we give all of this information to everyone who's needed. So you want to make sure that the survivor also gets this information, because unfortunately what can happen in abuse is that only the abuser gets the information and the survivor does not. So it's important that this is provided to everyone in the household. Lauren, anything else on that? Did I miss anything? Because I know that's really important. We good?
No, I don't think so. So this is so each CoC housing program, so that would be permanent supportive housing, rapid rehousing, and transitional housing, should provide both of these forms that are linked on this slide at all of the times that Liz just mentioned and that are on this slide. So because this form really is about occupancy rights, right? And like if your street outreach program, for example, you don't have housing, right? Their occupancy rights are not relevant. You would not need to, those kinds of programs would not need to provide the notice of occupancy rights. That would be confusing to people. So just our housing programs are required to do these things at these times.
So also, we want to make sure that we're assisting survivors in accessing every protection, including the emergency transfer. And agencies that are covered, so Lauren just alluded to it, the ones in slide 7, you can go back, have an emergency transfer plan, the CoC projects we talked about, and the ESG projects. This plan complies with the latest HUD guidance, and we're working on updating it to align with any new guidance coming out, and we will continue to do that. As we said, information is continuing to come on, but you have a sample provider emergency plan that you can take a look at. Okay.
So I just want to underscore this, right? So we have long had in CT BOSS a CoC-wide emergency transfer plan, right, for our CoC as a whole. And what this is new for people. What HUD made clear in the latest trainings that they did on the VAWA 2022 reauthorization is that you, as individual CoC funded housing projects, so if you're a PSH project, a rapid rehousing project, or a transitional housing project, you need as an agency to have your own emergency transfer plan. So that's what this link is here on this slide. So most of you probably do not already have that, because that is new information for us. So we thought that you could be covered under our CT BOSS emergency transfer plan, and HUD is saying that you each need your own emergency transfer plan. So what we did is we created a sample so that you don't all have to reinvent the wheel, but you do need to look at the sample, and there's things that you need to plug into the sample that are particular to your agency. So, so please make sure that you download this sample. Again, if you're a permanent supportive housing, rapid rehousing, or transitional housing program. And then we will work also on updating our CT BOSS CoC-wide emergency transfer plan to align to the latest guidance from HUD. But in the meantime, we wanted to make sure that you all have this tool to be in compliance with what HUD is saying you need.
Great, thank you. So it's important to know that folks are able to be transferred and have the right to be transferred to another safe dwelling unit, right? So again, we keep talking about safety and people's rights to be able to move and be in a safe place. So this happens if a survivor requests a transfer and believes that they are being threatened with imminent harm in the unit. So it's going to happen right away, or in the case of sexual assault, it occurred right there within 90 days of the request. And this part's very important. The first thing, if folks are able to stay in the unit and want to stay in the unit, and there is an open unit, that should be the first option. When there are no units available in the project, then the participant should be helped, is required to be helped to move to a new project. Any questions on that? Because that's really important too. Okay. All right, next slide. So in the emergency transfer plan, it's required that there is a prioritization laid out internally. So both for the organization and within coordinated entry, and transfer requests are to be prioritized before other admissions. So it's really important. Again, we're going to keep talking about it, safety and keeping survivors safe. And that's why we have to ensure that those requests are prioritized when it's time to change units or move.
So I just want to underscore a couple of things here. So that sample emergency transfer plan that we linked to a couple slides back, that meets this requirement for you, right? If you adopt that sample plan that we have offered, it does establish the required prioritization. So basically, what that means is that if you've got somebody in your program that has an emergency transfer request, they've got a safety, emergent safety need, and they need to get out of their unit, you should move that person into another available unit in your program, if such a unit exists, before you take the next person on the by name list, right? The same thing would apply if the available unit was in a different project within your agency, right? That person that has the emergency transfer need gets priority access to that unit, even if it's in a different project. So they get ahead of whoever's next on the by name list. And then the same thing also applies if the transfer is to a different agency within your CAN or in a different CAN. That person should be, the emergency transfer requests are the #1 priority. So these folks get ahead of whoever else is next on the by name list.
That's great. Thanks, Lauren. All right, we just said this, but just so folks know, for an internal emergency transfer, housing providers must allow the transfer to happen in the same project when that is available. So that needs to be the first, and that would be if it's the survivor's choice to stay right in the project. That is the first priority. Elaine, do you have a question?
I do. Good morning, everybody. So we had a situation just a couple of years ago, and we did follow all the rules, but it was not the actual tenant or the actual subsidy holder. It was the subsidy holder's partner.
Yep.
Who for all intents and purposes, actually met the requirements of chronic homelessness herself by episode. We happened to have an opening at that time that was in the CAN, which we pulled, and that particular person ended up with a subsidy and is part of our program. I've often wondered if we did the right thing. Again, all requirements were met.
So I want to just understand. So I think what you're saying, Elaine, and you'll tell me if I'm wrong, is that the situation was there were 2 people living together in a CoC unit.
Yes.
The person who was not at the time, the person who had qualified the household for the CoC unit needed an emergency transfer for whatever reason out of the unit.
Yes.
So you bifurcated the lease, you removed that person who was in danger from the unit. That person did qualify as being, you were able to document that they were chronically homeless. You move them into an available unit to keep that person safe, and they got their own subsidy because
Yes.
they met the chronic homelessness criteria. Perfect. That's exactly what you should have done.
Okay, great. Thank you.
Sure.
Thought I saw another hand, maybe. No.
I had
Yeah, there's several people with their hand up.
Okay, I'm sorry.
Randy, Deanna, and then Kim.
Oh, okay. Great.
Thank you. Trying to get my video to work, but it's not functioning. So my question is, so we're developing these emergency transfer plans. If you have somebody that's in a rapid rehousing or permanent supportive housing unit and they need to move because of a domestic violence incident, moving them is going to be a very time consuming thing, right? You have to find another unit. You have to inspect it, do all the things to be able to pay for another unit. So that can take months and sometimes, even longer. So my question is, you mentioned that the CAN, needs to prioritize people. Would we then, since we don't have any place to put them, and if it's something that they needed to feel safe, would we prioritize them for the next shelter opening until we could get them housed? Is that an appropriate use of transferring them safely to another location?
So I think, obviously we want to try to get people housed and not have them return to shelter. I think it's up to the victim to decide, because you're right. There may not be another unit that's immediately available, right? If there are congregate units in your CoC where, the unit is a physical unit and the person can move in quickly, that might be a good option. If there's an available congregate unit where you don't have to go out into the, sorry, I just put my hand in my camera. You don't have to go out into the private real estate market and find a unit for the person. I think shelter should certainly be a last resort. Yeah. But it should always be the choice of the survivor, right? So we'll talk in a minute about how do you define a safe unit. And the answer is that the survivor gets to decide for themselves what's safe for them. So I think where you don't have a housing unit immediately available and you're going to work as hard as you can to make that happen, but to also have, realistic conversations with people about what the timeline is likely to be and what other options might exist for them. Remember too that you don't have to limit yourself just to your CAN, right? So you can go to other CANs. You don't even have to limit yourself just to your CoC. You can go outside of the CoC. You can go to ODFC, and you can even go to CoCs in other states. So the options to transfer here are really quite broad. So you should be thinking expansively and talking expansively to people about what their options are.
So which leads me to the next point is developing our own plan for our own agency would only really work if we develop this plan in coordination with either our CAN or with like you say, another CoC. So we would have to work with these other CANs and our own CAN to align the policy. So let's say, for example, the CAN has a permanent supportive housing unit available, but we don't have one. We would have to prioritize them for the next opening over somebody else, but that's not our policy, that's CAN policy. So we have to work closely, it sounds like, with the CANs to align our plans.
So take a look at the sample policy that we've already developed for you guys. We did our best to try to do that alignment, right? So, the CANs all have statewide policies. The CAN statewide policies are that the folks with the emergency transfers get the first, dibs. So you shouldn't have to do, I think you should be able to adopt the plan, maybe with just a little bit of tweaking, that the sample plan that we've developed. If you take a look at it and you don't think that that's true, let us know, and we'll try to make the sample plan. We'll adjust the sample plan based upon any feedback that we get from you guys.
Thank you.
Sure. I think Deanna and Kim maybe had hands up.
And Kim said she's all set. Randy.
Okay.
Her question.
Me too. He pretty much asked the same questions that I had, and I appreciate also raising the concern within the CANs, because I'm hoping that they will be on board with, being able to move to other CANs and outside, and VAWA being the highest priority. So I appreciate that. Yeah.
That is not new, just so everybody knows. And so, and if you run into roadblocks at the CAN that we can be helpful in overcoming for you, please let us know. Our team is always happy to reach out to the CANs and to make sure that they also have all the information about what the federal requirements are.
Absolutely. But good point, Deanna. We want to make sure the CANs are all on board. And like Lauren said, we have great relationships. You guys have good relationships with the CAN. We're happy to pass along any information that would be helpful. Fenty, did you have a comment? Okay.
Yeah.
Do you want to say it, Fenty? That's helpful.
Yeah, I just like, just consider collaboration with domestic violence in the area. That, sometimes like there's funding that's more flexible. So yeah, just collaborate, like work together. We don't know everything ourselves, so.
Thank you, Fenty. That's such a good point. Thank you for raising it.
Absolutely. I'm going to do that 1-800 call Fenty because she knows a lot, as do a lot of folks on the call. But so thank you, Fenty. Everyone's going to come your way, but that's really helpful, right? So sometimes we are just thinking narrowly and there may be other resources out there. And we have to, like Lauren said, think expansively because safety is just paramount. And so whatever it takes to get the person to the next place safely is what's really important. So we talked about internal transfers, which actually I'll just talk a little bit about external transfers. So folks are going to have the right to say, nope, this isn't going to work for me. Lauren's going to talk later about how it's just really important that the survivor makes a decision where they want to be. Might be internal, but it also might be external. So it may be a different project, a different provider, a different CAN, or like Lauren mentioned, outside the CoC, outside of the state. And then as we've all been discussing, it's just really important that the CAN is involved in helping coordinate all of this and that all the CANs are helping coordinate this. So it happens sometimes in Connecticut because we're all so focused on doing our very best right here in our CAN, but just to remember that really we have to all work together to keep survivors safe. And so it may be someone outside of your CAN or outside of the state, outside of a CoC that may be coming for housing. Anything else? I think I'm going to pass the baton.
Thanks, Liz. So when you get an emergency transfer request and you are deciding what, is going to work for this person based on that request, super important thing to keep in mind is that you have to act based solely on the need as identified by the participant, right? So you can't, for example, say, you know what, I don't think this person is a reliable source of information. I don't believe her. I don't think she's in danger. I'm not going to honor this emergency transfer request. That is not allowed under federal law, right? So the federal law really centers the survivor and says that survivors are the experts in their own lives and have the best understanding of their own safety needs, and that when someone says that they need an emergency transfer in order to stay safe, we are going to take that at face value and help them to get that emergency transfer. And we are not allowed to consider other factors like, I think this person, might have mental health concerns, and that that this request is actually a result of those mental health challenges is another example. So, and then I mentioned this before. So, again, centering the expertise of the provider, right? When we think about what qualifies as a safe unit, a safe unit is a unit that the survivor says is safe, right? So that's it. So the survivor gets to determine whether or not the current unit that they live in is safe for them, and whether or not units that you are proposing to them or options that you are proposing to them to move, whether or not those are safe options for them. So it is not about your opinion or anyone else's opinion about what's safe. The survivor gets to define for themselves what a safe unit is, and you can't limit the number of times somebody can decline a unit, and you can't require somebody to accept a specific unit. So it's it's, obviously, the housing market is the housing market, right? So there's not going to be, 500 units that you can find, that are going to be affordable under the HUD program, and that the landlord's going to be willing to lease, and. So the person's choices are going to be constricted by that housing market reality. And so you should obviously do your best to help people to understand those limitations, but within those limitations, you're going to keep working to try to find a unit that that somebody believes is going to meet their need for safety. Did the question come up? All right. So, emergency transfer rights. So we always like to say that rights that someone doesn't know about are not helpful in protecting them. We know we've talked a bunch already this morning about the urgency of some of these situations. These situations really can be life-threatening for people. And so to ensure that we are helping the people we serve to stay safe, it's really important, sorry about that, that we tell everyone about these emergency transfer rights. So CT BOSS has a requirement that we provide this notice that's linked on this slide to everyone who is applying for assistance through the CAN. So the CAN should be providing this notice to everyone, as well as to everyone who is getting assistance for your project. And that should happen when the person applies, when they first enter your project, and at least once per year. So normally people are doing that at annual recertification. And you want to not just give them the notice. People get tons of paper from us, right? It's overwhelming the amount of paper that people get. So you want to make sure that you have at least a brief conversation about what the paper says, so that people understand what their emergency transfer rights are. And to remember that you don't know, right? You may not know that someone is currently in a dangerous situation. They may not divulge that information to you. So you want to do this for every single applicant and every single participant, regardless of whether or not you know that they have either some sort of current DV situation or a history of domestic violence. All right, so this is a new requirement. And so HUD has said that you must maintain records of all emergency transfer requests that you receive, and records of the outcomes. So you got the emergency transfer request, what you did with it and what are the outcomes, that should be documented. And that they are going to be requiring you to report on those outcomes annually. So they have said that they are working on how to implement that annual reporting requirement. It will most likely be, you will most likely be asked to report that through the APR, or for our SNOFO projects, that would be the quarterly performance report. APR is annual performance report, or if you've got ESG funded projects in your agency, it will most likely be through the CAPER. So you want to make sure that you are now getting ready for the fact that you're going to have to do that reporting, and that you are keeping track of all the emergency transfer requests that you get, and what the outcomes of those requests are. And like all of our documentation for the CoC program, you've got to make sure that you retain those documents for at least 5 years. If you get monitored by us, by CT BOSS, we will also request those records. So be sure that you're collecting that stuff. All right, I think our next slide is a poll. So Liz, you want to get... I think Liz is done. There we go. All right. So the first two of these are true false questions. And we'll give people a couple of minutes here to answer the questions, and then we will go over the results together.
Good. Also, Lauren, fun fact, we have 103 participants.
We had 107 at one point.
All right, I'll take your numbers higher. I like it.
I
It's
started
so
to get
exciting.
nervous. I started to get nervous about whether or not because we were stuck right at 100 for a while, and I thought, oh wow, I wonder if we didn't, because there's that cap.
Yes,
of 100
no,
unless we
Shannon
expand it,
did
but
it. We expected a big crowd, so Shannon upped our. So we're so excited you guys are all here today for this important topic. And a few people have asked about the recordings and slides, so I know people are going to share this with other staff folks, which is awesome.
All right, looks like we've got about 2/3 of our folks answering the question. I'll give another 15 seconds or so in case there are people that want to participate that weren't able yet.
Got a couple more coming in. Yeah.
Yep.
70%.
Thanks, Liz.
Sure.
All right. So, so the first question is true or false. It's up to the participant to ask for VAWA protections if they need them. So the answer to that is actually false. So remember we said earlier that one of your responsibilities as a provider is to be proactive to identify when people might need protections that they don't know about or that they're nervous about asking for their rights. So it really is when you learn of a situation where someone's unsafe in their unit, for example, even if they haven't asked you for an emergency transfer, you want to raise the possibility of an emergency transfer, right? We want to do what we can proactively to help keep people safe. The second question, emergency transfer requests must be prioritized over all other admissions. That is true. And then the last question, at which of these times is it required to give the notice of emergency transfer rights? And the answer there is all of the above, right? It's required to do it upon application, at project entry, and also at annual recertification, because we really want to make sure that people know about these rights so that they can stay safe. All right. Move us on to the next slide here. All right, so we know that the current housing market is really tough, right? It's hard to find units, even in the best of circumstances. So sadly, right, sometimes for folks who are survivors of these horrible circumstances, it can be even harder to find them a unit, right? So you might have landlords who are nervous about renting to somebody because of a domestic violence history, right? They might be worried about whether or not if there's fighting that's happening, their unit's going to get damaged, or it might be disturbing to the other neighbors. Sometimes, excuse me, sometimes there might be some criminal justice involvement related to the abuse. Somebody gets arrested in the context of some sort of domestic violence situation, and then that ends up on their background check when the landlord runs a background check. There's also, Liz talked a lot about this earlier, there could be financial abuse, right, that results in somebody having a poor credit score. And even though we're not doing things like excluding people for criminal justice involvement or bad credit in the projects that we own, our congregate projects, when most of you are doing scattered site housing, and the private market landlords out there might be looking at this stuff, and these can be real barriers for people who are survivors. And then also that we know that trauma from these situations can have really broad impacts for people, and that the impact of the trauma itself can make it difficult for people to do everything that they need to do in order to successfully navigate the housing process. And so we want to, of course, always be aware of these additional barriers that survivors face, and also aware that there are some VAWA rights that people have that can help to mitigate some of these barriers and to be really good advocates for our clients around those rights. And so I'm going to talk now about what some of those rights are that can mitigate some of those barriers. So when you've got survivors who are applying for or receiving rapid rehousing, permanent supportive housing, or transitional housing assistance, they can't be denied admission, terminated from the CoC project, or evicted by their landlord on the basis of factors. Liz talked before about adverse factors, and we're going to get more into that in a minute, that are a direct result of being a victim of abuse. And so we're going to look at some examples of that. So look at some more specific examples on the next slide. But basically, you cannot deny admission based upon what's called an adverse factor. And again, we'll look at examples of those adverse factors in a minute. If that factor is a direct result of the violent situation, the domestic violence, dating violence, sexual assault, or stalking situation, they can't be denied housing because the landlord has concerns that that violence may cause problems in the unit. And they can't be evicted because of noise or other disturbances if those things are a direct result of VAWA protected violence and abuse. So here are some examples. So these are some examples of adverse factors that cannot be used to deny support or evict a CoC participant if these things are the direct result of the abuse, right? So I won't go through everything on this slide, just want to highlight a couple of these things. So an example would be someone's abuser was using their credit card, and now the person has terrible credit, right? Because that was a direct result of the abuse, it's not a poor credit history, should not be a factor in, deciding whether or not someone is, can get a lease. Another example might be somebody lost a job because their abuser kept showing up at their workplace and their employer fired them because of that, right? And so they have poor credit because of that job loss. That would be another example. They might have some issues on their rental history, right? They may have been evicted before because of noise that was related to fights that were happening in the context of an abusive relationship, or maybe some property got damaged in the context of that, during a fight, something got broken, holes in the walls, broken windows, whatever. If those things are a direct result of the abuse, those should not be factors that prevent somebody from getting a lease. And then finally, criminal record. We know sometimes in domestic violence situations, both people end up getting arrested, or multiple people end up getting arrested, and those arrests can end up showing up when someone's doing a criminal. Those arrests or those convictions can end up showing up when someone's doing a criminal background check. So those, when that happened in the context of an abusive situation, those criminal record things should not be used to deny someone housing. And that includes maybe crimes related to sex work. We know sometimes survivors are coerced into sex work by their abuser. And again, criminal records related to those kinds of crimes should not be a reason someone doesn't get housing. Now, I know many of you are thinking, I'm surprised someone didn't put it in the chat already. Do these protections apply to private market landlords? So what I'll say to that is that the information that we have from HUD, some of you may have attended excuse me, the VAWA training series that HUD did recently for CoC projects. There were a gazillion questions to HUD about this, and they really sort of stayed in their lane around how these things apply to CoC grantees and CoC subrecipients, and they sort of shied away from responding to detailed questions about the obligations of private landlords. So what I would say to you is be a good advocate for your client, right? Err on the side of, helping the landlord to understand how these things might be related to the abuse, right? And trying to get the landlord to rent to people, despite these factors. And if they won't rent to people despite these factors, try connecting people to a legal services provider. Explain to the legal services provider that the reason that the landlord's not renting to them, I think, frankly, it's easier probably to pursue these things at the back end, right? If someone's trying to evict someone, it's going to be easier to assert these rights than it is going to be at the front end when they're denying someone housing. But in either case, when you've got these situations, I would really encourage you to connect somebody to a legal services provider and have that legal services provider really look at the specifics of that situation to see whether or not there are some VAWA rights that the person might have that's going to prevent even private market landlords from doing these things.
Lauren, we have
I
a
think we
question.
have.
So one
Yeah.
question you just addressed, you were doing some mind reading there. And then we have a question, can a landlord charge the tenant for property damage resulting from DV?
You know what? I don't know the answer to that. I've not seen anything. I don't know the answer to that. So we will look into that to see whether or not there's anything in the information that we have. I'll just make a note for myself. So we'll get back to you on that if we have anything. And if we don't have anything, then what I would say is either two options, or if you need the answer to that more quickly, then we're able to get back to you. You can submit the question to HUD through the HUD AAQ portal. And if you don't know how to do that, let us know. Or you can talk to your local legal services provider and ask them that question. All right, was there another one, Liz, or that was it?
Yep.
All right, I'm gonna move. Okay, thanks. So and then again, so there's also, failure to pay rent might be the result of an adverse factor that's related to the abuse, right? So somebody was injured by their abuser and can't go to work, right? They lost their income and they're not able to pay rent. Again, I'm not going to go through all of these things. They lost wages because they were had to be in court all the time, or they had a lot of counseling appointments related to the DV, or, they had medical appointments. Maybe they had significant medical expenses because they were hurt from the abuse. And because of those things, they couldn't pay rent. Those could be considered adverse factors, and they could be, they should not be evicted because of those adverse factors. Now, I think in our congregate CoC projects where your agency is, owns the building and is receiving the CoC funds, you should not be evicting people or denying assistance to people based upon these adverse factors. I think when it comes to private market landlords, it gets a little blurrier. And as I said before, be a good advocate for your people, try to help them to assert these rights and get a legal services provider involved when necessary to determine what might be feasible through the courts to prevent somebody, particularly to prevent folks that are facing eviction from getting evicted. All right. So this next slide, I think most of this, I think I said all of this already. I'm not going to repeat this. All right. So one of the things that you are required to do for all of your CoC housing programs, regardless of whether or not they are, congregate projects or scattered site projects, when you are leasing units with CoC funds, even when you're leasing those units with a private market landlord, all of the leases need to have a VAWA lease addendum that asserts these VAWA rights. So it basically says things like, the landlord, isn't going to evict somebody because of noise violations that are related to domestic violence. It's not optional. In order to get the rental assistance through the CoC programs, the landlords have to execute these VAWA lease addendums. The most recent version available from HUD is linked here on this slide. You will note that it is quite out of date. So it does not include not only the 2022 reauthorization, but at least one reauthorization before that and perhaps two authorizations before that. So they're pretty behind in getting this updated. We will let you know as soon as we get a new one from HUD. In the meantime, you can just use this version that's linked to here. So the question is, what if the landlord refuses to sign? We have seen that recently. So technically, you should not be leasing units without this VAWA lease addendum in place. So all of your CoC units are required to have this VAWA lease addendum. And if the landlord is accepting, which in Connecticut they should be, because there's a law in Connecticut that says that they can't discriminate based upon how someone is paying for their rent. I would try to explain to the landlord that this is a federal legal requirement, and that they don't really have the option to say no, because they are required to accept subsidies in Connecticut. And, once you've accepted a subsidy, these legal rights apply. I will say that even if the landlord didn't sign the lease addendum, right? The law is the law. So if somebody's trying to evict someone for a VAWA protected reason, again, even if they didn't sign the lease addendum, get a legal services provider involved. There's a decent chance that with the help of that provider, you can prevent the eviction, even if the landlord never signed the VAWA lease addendum. Although, again, it is required for all of your projects, and it would be a finding if we came out to monitor or HUD came out to monitor. It could be a finding if you've got CoC units under lease that do not have the addendum in place. All right. So now we're going to switch gears a little bit. We're going to talk about lease bifurcation. So this is another really important tool to help people stay safe. And basically, bifurcation is kind of an overly complicated word that means to divide a lease so that some of the tenants in the apartment can be evicted or removed from the apartment. It doesn't necessarily have to be go through the whole legal eviction process. While the remaining household members stay in the unit, and those people who remain in the unit, their lease and occupancy rights remain intact. So basically, you can bifurcate or separate the lease so that some of the people are removed and some of the people can stay in the unit. So you would use this, for example, where there is someone being abused by someone else that lives in that unit. Bifurcate the lease to remove the abuser from the unit, and the survivor and any other folks that live in the household can remain in the unit. And we're going to talk in a minute about how we're going to look at a specific case and talk about how assistance continues or doesn't continue for both sets of people, the people that remain in the unit and the people who are removed in the unit. So if the tenant being removed was the eligible tenant, meaning that was the person who qualified as for eligibility under the CoC rules when they first came into the program, the remaining members of the household have until the end of the lease to establish whether or not they were eligible. So Elaine, Matt earlier talked about an example of this where they were able to determine that both parties, in fact, even though only one party had, had the eligibility documentation when the household first moved into the unit, in fact, they were able to determine that both parties met the chronic homeless criteria and continue assistance for both parties. So the tenant being removed from the unit has up, so that if the person being removed from the unit is not the eligible participant, that person has 90 days to establish their eligibility, and that can be extended for up to 60 days.
Deanna has a question. She had her hand up.
All right. Hey, Deanna.
Hi, you kind of answered the first one, as far as, if it were to happen and the person being removed was not eligible for services, but I think my question is around, so when we talk about they have to the end of the lease, so say we have had a household that's the eligible participant, they are the one that needs to be removed, we bifurcate the lease, the rest of the family stays in the unit, we rehouse the actual cert holder. So who pays for that unit to the end of the lease?
Yeah, so great question. And we're going to answer that question right now. You anticipated Susan's situation, Deanna. So
Awesome.
let's go through Susan's situation. And then if you still have the question, if it didn't get answered, let me know, okay? So Susan, in this case, is the qualified CoC participant. There have been multiple DV incidents with her romantic partner, and who is the aggressor, often varies. And following the most recent incident, there's a protective order that says that Susan cannot return to the CoC unit. And you, of course, have done all your great work providing support and resources and education and all of that. So here's our questions. I think this gets at the question that you were just asking, Deanna. The first one is, can Susan be removed from the unit and her partner allowed to stay? So even though Susan, in this case, is the CoC qualified participant, there's a court order that says that she can't return to the unit, right? So absolutely, you can bifurcate, even if there isn't a court order, right? If, Susan is the abuser and the partner asks to, to bifurcate the lease in order to, you can also do this. There doesn't necessarily have to be a court order, although in this case there is. But even though Susan is the CoC qualified participant, you can bifurcate the lease and allow her partner to stay in the unit. So the answer to question number 1 is yes. Question number 2, can the CoC project continue to assist Susan? So remember, Susan is the qualified CoC participant, and absolutely, you should continue to provide CoC supportive services and rental assistance to Susan, regardless of whether or not she is the perpetrator or the victim, right? There's nothing in the CoC rule that says that we don't help people who are perpetrators of violence, right? We're going to help Susan regardless of whether or not she's the perpetrator or the victim. So you can help her to locate a new unit where she can use her CoC rental assistance. And now the third question is, I think, the one that gets at Deanna's question. So let me know if it doesn't. Can the CoC project provide rental assistance to Susan's partner? So if Susan's partner remains in that CoC unit, she's going to be provided until the end of the lease with the opportunity to establish her eligibility under the CoC program, right? So whatever depending upon the kind of program it is, she has until the end of the lease to establish that she is eligible. You're going to be able to continue to pay rental assistance on that unit for up to 30 days from the end of the month in which Susan vacates the unit, right? Obviously you're going to be able to continue to provide CoC rental assistance if Susan's able to establish that she's eligible for that. But even if Susan isn't able to establish that she's eligible for that, you can continue to pay the rental assistance for up to 30 days from the end of the month in which Susan vacates. So Beyond that, those 30 days, in order for you to continue to pay, the partner would have to establish that she or they are responsible, or excuse me, are eligible for the assistance. So to answer your question, Deanna, it depends who's going to pay. In some cases, you're going to be able to continue to pay if she's eligible, or you're within that 30-day window. And then in some cases, she's going to have to pay. And that, for a lot of the people, I'm sure, that are living in these units, is not going to be feasible, right? So if they can't establish eligibility, they're probably going to need to find someplace else to live, unfortunately, because you're not going to be able in the long term to continue to subsidize that unit for somebody that's not eligible for CoC assistance. All right.
We've got 2 hands up. Imani?
Yeah, I have a quick question. So regarding, let's say the CoC program was able to find another unit for Susan and start the rental subsidy with the new unit, and the landlord for the old units, regardless of whether somebody is there or not, states, well, you signed a 12-year lease abiding, and legally you have to abide by it. Because I know, not with anything specific relative to this, but I've had landlords bring that up to us, even though we have moved the tenant and the, whatever, what have you. So what are the guidelines when it comes to?
Yeah, so that's going to be a situation where, hopefully they've signed a VAWA lease amendment, and it's covered in the lease amendment, right? So, so people are going to be able to get out of the lease when they have to, for safety reasons. And if the landlord either didn't sign the amendment, or I'm saying the wrong thing. I'm saying amendment, addendum. Sorry, if the landlord didn't sign the addendum, or signed the addendum but isn't honoring the addendum, then you're going to want to help that person get attached to get connected with legal services, to fight whatever the landlord is whatever charges the landlord's trying to put upon the person.
All right, Lauren, we've got a couple follow-up questions, I think. So
Yeah.
Dan, you have a question, then we've got Kim and Amanda. Yep. Go ahead,
My
Dan.
question, so what happens if fiscally a grant cannot take on the responsibility of paying for that person that was not the cert holder, and they are eligible for services?
I know you guys were going to ask all these hard, good questions. So yeah, I mean, the reality is that the budget that you have is the budget that you have. Now, a lot of times, particularly in this housing market, we've got CoC programs that are not fully spent because you're having difficulty finding units and for other reasons. And so certainly if there is room in your budget, you should continue to pay. But that doesn't mean, just remember that, it may mean for a short time you are over enrolled because now you've got 2 units rather than just 1 unit. It doesn't change the contractual commitment to the number of units that you're going to support moving forward. So once a unit becomes vacant, you cannot fill that vacancy in order to ensure that, let's say you've got, your project application is to do 20 units, and now suddenly you've got 21. When a unit becomes vacant, don't fill that vacancy, and then you'll be back to 20. And then hopefully that will help you to stay within your budget. But sometimes that's not the case. Sometimes you guys are spending right up to the penny and are even, sometimes, although hopefully not, at risk of overexpending. And certainly I think, it's your agency's call whether or not the agency has other resources that you can use to help continue to pay that rent. If that is not an option, then what I would say is work with your CAN to get the person transferred to a different program that has some wiggle room in the budget and can help to pay for the program. And it may be even within your own agency, right? You've got another CoC project or another kind of housing subsidy where you can move the person with their agreement if it's another kind of subsidy. So there are lots of options, but you're right, Deanna. It may not always be fiscally possible within the budget that you have available to continue to provide assistance to both units.
So Kim said her question was answered, and Amanda has a question.
Thanks. So my question is, what happens if it's basically the opposite situation from Susan, where it's the non-CoC eligible person who has to leave the unit? They have up to 90 days to establish their eligibility, and we would have to create a cert for them. Or do they also have up until the time that the lease of their prior unit that they're being asked to vacate is up to establish eligibility?
Yeah, so let me just make sure I got this right. So the person, you're bifurcating the lease, the CoC eligible participant is staying.
Correct.
And the person that's not CoC eligible is the person that's leaving. Yeah. That person has up to 90 days from the point that they're being removed from the lease to establish their eligibility under the CoC program. So if they establish their eligibility within that 90 days, you can opt to extend it for 60 days. But if they establish their eligibility within 90 days, then you should assist them through the CoC program.
And if they're unable to establish their eligibility, our obligation to them ends?
Yes.
Thank you.
All right, any other questions?
Yep, Amani, do you have another question?
Yeah, I have to follow up off Amanda. So let's say in the example that Amanda just gave, let's say not the CoC participant, but like she said, the other person involved needs to vacate, and let's say it's due to like a restraining order, like it needs to be immediate resolved. Then what happens there?
I'm sorry, say that again. So the other person needs to leave.
Yep, and let's say they have a court order that they have a restraining order, they can't be in the premises of the CoC participant who lives in that same unit. Then what happens there, because that needs to be immediately resolved, they can't legally go back into the department there.
Yeah, so I think it's the same scenario that Amanda was just, I think it's the same answer. I shouldn't say the same scenario. It's the same answer that I just gave for Amanda, right? So regardless of whether or not there's a court order or not that they have to leave, right? If it's an emergent safety issue, right, you're going to try to bifurcate the lease and act in an emergent way, right, to get the person out so that the other person can be safe. And if the person who's in this case has a court order that says that they cannot go back, is going to have that same 90 days that we just talked about with Amanda to establish their eligibility. The court order has no impact on that.
Okay, thank you.
Sure. All right, I'm gonna, because we've got a bunch of slides to cover, so I think what I'm gonna do is get through the rest of the content and then hold questions to the end so that we can get through all of the content. And if we don't get to all of the questions, I can stay on for a little bit at the end to get to all of the questions. And then also, we are always, as Liz is so good about reminding everyone all the time, we are always available to you. So if you can't stay on and you didn't get your question answered, just call Liz or I or email us and we will get your question answered. All right, so documentation requirements. We're going to talk about when someone asks for protections under VAWA, what documentation you can require them to provide to you. And so basically what VAWA says is that when someone seeks to exercise their VAWA rights, you may provide protections based just upon the request, right? So you don't need any documentation. Someone says they need an emergency transfer, you don't need any documentation, right? You just say, okay, you need an emergency transfer, let's go. You can choose to ask for documentation, but the participant has the right to choose from among the allowable types of documentation which they're going to provide, and we're going to look now at what those allowable types of documentation are. So, so any of these is an acceptable form of documentation, and it's the survivor's choice which of these they're going to provide. And the first one is a self-certification. So, if you decide that you want any kind of documentation, you have to accept this HUD self-certification form. It's linked here on the slide. Or another form of self-certification, a letter from the participant, for example, saying that they're self-certifying that this is the situation, right? You can also accept, law enforcement, something from the courts or from the police or another kind of administrative agency, or documentation from a professional like a, counselor at a victim services agency, or, a doctor. That's been, a therapist that's been treating the person. Any of these are acceptable. And remember, the victim, the survivor has the right to decide which of these they are going to provide. If you are going to ask for documentation, you've got to make that request in writing, and you've got to allow the person at least 14 business days to respond. I mean, I think generally we want to be as flexible as possible in these situations. Our goal, I'm sure, for all of you is going to be to help people to stay safe. So this is not, they've got to reply within 14 days. This is, you've got to allow them at least 14 days to reply. And, we want to be, again, like, if people need more time than that, please give them the time that they need. And again, you're going to accept whatever form of documentation the survivor chooses to provide. Now, the only time you can require documentation beyond self-certification is if there is conflicting information. So, for example, you get, self-certifications from two different people that both are in the program or both live in the same unit, and those self-certifications say two completely different things, right? So you've got conflicting information. You can require then documentation. One of the other two forms of documentation we just looked on the previous slide, but you don't have to, right? You can decide it doesn't matter. You're just going to work to get both people housed in a situation that they feel is safe. So this is a can, not a must. All right. So confidentiality. So, we know that disclosure of any kind of information that might help an abuser to find, the target of that abuse, the survivor, that disclosure, that breach of confidentiality can be incredibly dangerous. And so we want to do everything we possibly can to protect survivors' confidentiality, and we are legally required under VAWA to do that. So the emergency transfer plan that your agency puts in place has to ensure that you are, these are just examples, that you're not going to disclose the location, obviously, of the place where the person is moving. And that really is, you shouldn't be disclosing that information to anyone, right? Not just to the abuser, right? You should not be telling people, that information should be confidential where the person has moved. Only people who need to know. If you've got a case manager that has to visit the person in that apartment, obviously that person's going to need to know. But really, you're only going to be providing that information in a very strict need to know basis. And then this is not different, right? Victim service providers under VAWA, in order to protect people's confidentiality rights, are not allowed to enter information into HMIS. They must enter information into the HMIS comparable database. So we want to take these confidentiality protections really seriously, because it can literally be a matter of life and death for a survivor. All right. New in VAWA in 2022 are these prohibitions on retaliation. And these things apply to public housing authorities, for example, and They apply to all of the different kinds of covered housing programs that we looked at earlier in the presentation. And they apply both to the owners and to the property managers, right? So, you know, a private property management company is also subject to all of these VAWA requirements. You know, and basically what the prohibition on retaliation says is that you can't discriminate against someone for exercising their VAWA rights, right? So for example, you can't decline to renew a lease because someone has repeatedly sought an emergency transfer, right? You can't decline to renew a lease or threaten to decline to renew a lease because someone has bifurcated the lease in the, you know, previously. So, you know, there basically can't be any kind of threats or coercion or intimidation that interferes with someone's right to exercise the protections that they are entitled to under VAWA. All right. This is also new in VAWA 2022. So people experiencing domestic violence, right, may need to call 911 in order to stay safe. And VAWA protects their right to do that. So covered housing projects cannot penalize someone for exercising their right to seek help from emergency services. So I'm not going to go through all of these examples, but a couple places where this might apply. Don't tell people that they have to contact staff before they call 911, right? You should never do that. People are always entitled to call 911 if they feel like they have an emergency situation, and we never want to impede their ability to do that. You know, don't threaten to renew a lease, don't threaten not to renew a lease because someone calls 911 a lot. And, you know, you don't want to say anything, you know, property managers, I don't think you guys would ever do this, right? But also like property managers should not be doing this. You don't want to say to someone that, hey, you know what, you've been calling 911 a lot. You might want to think about that because, you know, the landlord's going to see you as a troublemaker and they're not going to want to renew their lease, right? None of that is allowed under VAWA. And then, you know, sometimes local governments, right, localities pass laws that are not allowable under federal law, right? So VAWA has certain restrictions against what are commonly called nuisance property or crime-free programs. So, for example, if your locality has a law that fines people for excessive 911 calls and there's no exception in that law for domestic violence situations or for people with disabilities, then those laws are not legal under federal law. And so if you know of an ordinance in your local town that, you know, does any of these things, you want to make sure that you're advising, you know, if you're working with somebody that's subject to some sort of penalty under one of these laws, you want to make sure that they know that it's not legal, even though it's a local law. Federal law supersedes local law, and you should definitely put them in touch with a legal service provider because they should not have to pay those fines or penalties. All right, so we're going to do a poll. All right, give you a few minutes to answer the questions.
Right. We want to do a last call. Anybody who wants to jump in and answer, and then we'll close up in a minute or a couple seconds.
All right, let's close it out, Liz, so we can get through the rest of the slides. Excuse me. All right, so the first thing, a PHA, Public Housing Authority, is refusing to lease a unit because of previous property damage that happened when the applicant was being beaten by his husband. Yes, that is prohibited under VAWA, right? So that would be considered an adverse factor that's related to the abuse, and it should not be a reason why someone is denied a lease at, the PHA units are covered units. So the second one, a rapid rehousing tenant lost her job because her abuser kept showing up at work, and her landlord is now evicting her for non-payment of rent. So in that case, what I would say is try to get that person hooked up with a lawyer who can advise on whether or not there might be an argument to protect the person from eviction under the VAWA protections. And then the third one, a PSH property manager tells a tenant who is being abused by her daughter's father that she better watch herself because the management is unhappy about the fights between them. And again, that would definitely be prohibited, right? We don't want to use any kind of threats or coercion or intimidation. Those things are prohibited by VAWA. All right, next slide. All right, so people know, probably most people on the call know, that in your CoC programs, you've got a particular budget, and that budget says certain activities that you are allowed to expend CoC funds on. We call those eligible activities. And you can only expend CoC funds on the things that are listed in your CoC program budget as being eligible. Sorry, I'm having a little technical difficulty here. Give me a second. Okay, there we go. So in the 2023 competition, so in last year's CoC competition, when you guys apply for your money, had added certain eligible expenses related to VAWA as options in your CoC budgets. It was the first time that those VAWA 2022, the reauthorization, added new VAWA eligible activities. So we'll look at some specific examples on the next slide, but they're basically these two broad categories that were added. The first one are costs related to emergency transfers, and the second one is a cost related to compliance with the confidentiality protection. So for the first time starting last year, if you've got these budget line items in your budget, you can expend CoC funds on these eligible activities. So, and here is a list. We'll start with the emergency transfer facilitation, what's eligible under that budget line item. So moving costs, right? Sometimes if someone's gonna move, they might have furniture, whatever, and they're gonna have to hire a mover in order to get that stuff moved. Travel costs, someone may need to travel far in order to stay safe. And so those travel costs can be an eligible CoC expense. A security deposit, right? Like maybe you don't have enough money in your rental assistance budget to pay another security deposit. You can pay for a security deposit out of the VAWA emergency transfer budget line item if you have such a budget line item, and we'll talk in a minute about how you can get such a budget line item. If somebody needs money for a utilities deposit to establish utility service in their new unit, that's eligible. If there are applications or broker fees or even pet fees associated with them getting a new unit, as long as the pet is necessary for as long as any of these things are necessary for safety, that they are eligible housing costs. There might be some technology needs, right? Maybe the person needs a security system and they need an internet connection in order to hook up that security system. They want a Ring camera. That those technology needs can be paid for under the emergency transfer budget line item. There might be some additional case management expenses or housing navigation, right? You're going to have to find this unit. That there might be, you might need to see the person more often. Those expenses can be billed under the emergency transfer budget line item. And then the second eligible budget line item that was added is confidentiality compliance, right? So, you might have some costs associated with how you are evaluating or monitoring whether or not your team is compliant with the confidentiality requirements. You may need to develop some corrective action strategies if you find some non-compliance. You might need to do some training for your team on what the confidentiality requirements are. If there's any reporting that you need to do related to the compliance, and then any staff time spent on these things are going to be eligible under that confidentiality budget line item. I think most of the costs that are going to be incurred are likely to be under the transfer budget line item. There's probably not as many costs on the confidentiality budget line item. So, okay, so how can you get such budget line items into your CoC project? So the first thing is CT Boss has a new project RFP out right now. If you've not seen it, go to our website. It's posted on the website. And these are eligible activities on the VAWA budget line items. And you can request in a new project budget funds for these eligible activities. If you've got a renewal project application, you will have the opportunity again during the 2024 CoC competition. We think, I mean, we never know what HUD's going to do, but we think that they will give us the opportunity again for you to shift funds from your existing budget line items into one of these budget line items. Now, I know for many of you, if you are already fully spending on your other budget line items, this is not so useful, right? It's not new money, it's just moving money from one category to another. But if you are having difficulty spending on your existing budget line items, this may be an opportunity for you to fund these eligible costs and also reduce your underspending. You can also, if you've got, you want to make the change now to an existing CoC contract for the current operating year, right? You can also do that, but to do that, you have got to request a grant agreement amendment through your field office. And just remember that CT Boss does require that you first, before you go to the field office to get a grant agreement amendment, that you go to your CAN and get approval from your CAN, that everyone in the CAN agrees that it makes sense to use the CoC funds in this manner. And then once you get that grant agreement amendment from the field office, please don't forget to submit it in Zengen so that we have it, and email us to let us know that you've done that, so that we have record of what your current budget actually is, and our records are kept current. Okay, we got through all of our slides. So I am going to open it back up for any remaining questions. If you feel free to hop off now if you'd like. We appreciate, actually, let me just go through a couple of last things before we do questions, in case people want to hop off. So this is just a link to some HUD information with more information and about all of the different forms that are associated with complying with this VAWA stuff. And then this is just, we've done recently a whole series of new compliance trainings for people on administrative and policy requirements, on participant eligibility documentation, on housing requirements, fiscal requirements, and then grant management requirements. All of these webinars are recorded and they're on the CT BOSS training page. So if any of them would be helpful to you and you missed them, please go and watch them. And then this is just our contact information. Again, we're always available to you to answer any questions you have, so don't hesitate. And if you have any questions now, unmute or put them in chat and we'll answer them now. We've got about 7 minutes left.
And I know Kim had a question. So Kim, if you want to kick off.
Hi, yeah, just a quick question about the emergency transfer plan. We once had 2 tenants with vouchers in one unit, privately owned by a landlord, who were both claiming that they were in a abusive situation due to both tenants verbally abusing each other and making each other feel safe. Luckily, one of them moved, but if it's in a case like that they're in the same building, we don't own the building, it's privately owned, and they're saying they feel unsafe due to another tenant in the building, does the emergency transfer plan, would that work there?
Yeah, it doesn't have to be somebody that lives in, you could be quite unsafe because there's someone in, remember what qualifies as a safe unit is what the tenant defines as a safe unit. So it doesn't necessarily have to be someone in their unit that is the abuser. It could be someone in the building. It could be someone not even in the building, right? The person could be at risk just because the abuser knows where they live and they need to move to a different building.
Okay,
And again,
thank you.
Sure. Other questions people have? Good question, Kim. Thanks.
Anyone?
Don't be shy, everybody. If you've got questions, let us know. You guys asked a lot of great questions already, so we really appreciate it.
Absolutely.
I think it helps because every time you ask a question, there's at least one other person on the webinar that had the exact same question. So we appreciate those of you that are brave and speak up.
Absolutely.
I have a question. Sorry, I sound very stuffy. So say you have
Me too.
say you have a client that has had a domestic situation in the household, in the apartment, and they were granted a protective order, like a residential stay-away. And then the apartment is telling the client that they have to pay $1,500 to break the lease. Can VAWA should be able to cover that, right?
So yeah, so I think so I just want to make sure I'm understanding the question. So so you're not asking whether you can pay that $1,500 under your CoC grant. I think you're asking whether or not the person can not have to pay the $1,500 in order to break the lease. Okay, yeah.
Under VAWA,
yes. So the situation is there's an abusive situation happening, regardless of whether or not there's a court order, but in this case, there's a court order that says that the person cannot return to the unit, and the landlord saying that the person has to pay $1,500 to break the lease. No, that is not allowed. And you can advocate with the landlord. I would check to see if there's a lease addendum that's been signed by the landlord regardless of whether or not there's a lease addendum that's been signed. If you're not able to get the landlord to understand that that is not allowable under VAWA, then I would refer the person to a legal services provider.
Okay, so it's not allowable under VAWA, even if it's not rapid rehousing or any form of housing, if it's just a regular.
So everything that we're talking about is about CoC projects.
Yes,
So
yes,
it,
I
yeah,
understand.
so it would,
So
yeah,
it's just
so,
that's just a separate question I was asking. Okay,
so I don't know, like I, you know, how this all applies to every other kind of housing that's out there in the world. I can't answer that question. I'm sorry.
okay, but my real question was under the CoC housing. So, okay, so you
Yeah.
answered both questions for me. Thank you so much.
Great.
Thank you.
I had a question, Lauren. So say we do an emergency transfer, there's a DV situation, they're separated. We do an emergency transfer. That person allows that person back into their life. We have another DV situation. Is there any sort of limit as to how many times, or do we just continue with emergency transfers? And
Yeah, so we just, you do all your great case management work to help, do all your motivational interviewing work to help people understand the risks and the, possible scenarios that are going to come up. And then you just keep, that there's no limit on the number of times that people are able to request an emergency transfer.
thank you.
Other questions people have?
I'm not seeing anything else.
All right. We really appreciate